fundamental facet, and I think this is absolutely well accepted under Indian law as it is under other laws, is the doctrine of separability. And that is, in my respectful submission, fundamental to the consideration, because it is the doctrine of separability which looks at the validity and enforceability of an arbitration agreement. And why that becomes important is that there are lots of passages, I take your lordship to Chloro and other decisions, which talk about the performance of a contract and obligations that a party may have undertaken under it. But today what your lordships is looking at is in relation to a non-signatory and performance under a separate doctrine, which is a separate arbitration agreement. There may be rights that you may exercise where you commence an arbitration. If somebody initiates an arbitration against you and says, sorry, you are bound by an arbitration agreement, you are obliged to arbitrate our dispute, you can't go and file proceedings in court or do something else. But that is fundamental in my respectful submission when your lordship is considering this case, because performance has to be judged from the performance of rights and obligations under an arbitration. The second aspect, which is extremely relevant for your lordship's consideration, is India's acceptance of the localized theory of arbitration. Now, if your lordships recollect, in Bharatiya International, we diluted that principle. We went a little step ahead and we said it doesn't matter whether the seat of arbitration is something global. Paragraph 88 of Balco, where the first U-turn came to becoming more just said in our opinion, and he was looking at section 2, the authority does not relax the territorial principle adopted by the Arbitration Act 1996. It certainly does not introduce the concept of delocalized arbitrations into the Arbitration Act 1996. Now, the reason why that is critical, Malone, is this. France, as your lordships is aware, does not follow the localized approach, and Dow originates from France. France follows the transnational. On the other hand, that's one further reason why your lordship as well, Singapore does, is because Singapore and England follow the localized approach. Singapore is a model law country, because I have, in fact, in my footnote, and the decision is there before my lord, there's a decision called PT First Meetings, the 2013 decision of Justice Sundaresh Menon, when he just, in fact, recently been elevated and become Chief Justice. And in that case, he has very categorically set out that Singapore followed the localized regime. The reason why that is relevant is because there is a national law which governs the conduct of arbitrations, unlike France, where it doesn't matter. And for the French aspect in relation to this, can I just draw your lordship's attention? Your lordship needn't open this right now because it's all there. You can, lordship, just mark this, page 1171 of my edition, which has the article from Bernard.
Why don't we read your note? Then we can maybe go through some of your documents and
I certainly will do that.
How long is your note?
It's a 15-page note.
Let's run through the notes so that we get the whole bearing. Get a picture of and then we can go through, I'll touch upon the judgment, etc.
I'll absolutely do that. The reason why I made that, why I was just making a reference to Hanishwar, because Hanishwar draws that comparison at page 117.
So let's go to para 5 now.
Yes, can I just make 2 or 3 points just before I get to para 5? I'll just run through the note. The third doctrine is, we've accepted that contracts are certain and terms must be read as such. Now, why the average public policy? Because your lordship is considering a doctrinal approach, and there's no difficulty with that. One, we want to be considered as a hub for arbitration. Two, and this is slightly critical, awards which are made in India need to be enforced outside of India. So, your lordships wouldn't want to be in a position, and I made that good paragraph.
So let us read on. This just read the note actually.
So this paragraph becomes essential when considering India's above legislative policy to one, be considered as a hub for arbitration. Two, to ensure that awards which are made in India would be enforceable outside of India in terms of the New York Convention, with the Articles 2.1 and 2.2, and enforce awards in India which are consistent with the New York Convention, which your lordships will have bear in mind, section 44 of the Arbitration Act. Because this decision will go across all these 3 paragraphs. These principles must drive, in my respectful submission, the interpretation of Section 7 of the Arbitration and Conciliation Act, insofar as ascertaining whether an arbitration agreement can be extended to non-signatories, as well as appreciating the doctrine of claiming through and under as set out under Sections 8 and 45. I'm sorry, I'll just take a 20-second digression. Imagine a scenario where a suit is filed in India, and the court under Section 45 refers the matter to arbitration, which is say in London or Singapore. And they turn around and say, sorry, under our law, we cannot start an arbitration against a non-signatory. Because jurisdiction will be the law of the seat. So therefore, if an application is which I've dealt with later, it's in fact, in my respectful submission, a defendant's doctrine. If such an application gets filed, how does the court proceed? Does it just send everything to arbitration? Person goes to Singapore, then comes all the way back and says, sorry, I can't do anything. Suits anyway gone. Arbitration is gone. Time is spent. Now let's paragraph 6. Bearing that, it is respectfully submitted that as a seat, India cannot be overzealous to extend the jurisdiction of arbitral tribunals to non-signatories who may simply be a part of a group of companies. 2. Courts applying Indian law also ought not refer parties to arbitration, whether domestic or international, on an expanded interpretation of claiming through and under. And tribunals also ought not put themselves in a position where, as it transpired in Dala Real Estate, an award is passed in the seat court and is held not to be enforceable by an enforcement court because different principles will also have been adopted. And why this is again extremely important is what I've said at paragraph 7, because your lordships is dealing with the question of jurisdiction. It is imperative to bear this in mind that since this issue touches upon the jurisdiction of arbitral tribunals, any interpretation by this honorable court ought to be consistent with internationally accepted principles for joining a non-signatory to an arbitration. That is because the issue of jurisdiction is considered de novo by the court, whether it be the setting aside or the enforcement. This has been set out by the Singapore Court of Appeal and PT First Media, where the court stated that jurisprudence of the Singapore Court has also evinced the exercise of de novo judicial review. The Singapore International Commercial Court, this is in fact Sir Bernard Eder in CPU, where he stated a challenge to the tribunal's jurisdiction should be heard by way of a de novo hearing, as well as Dala, where at the enforcement stage, what the court said is, our view that an arbitral tribunal's own view on its jurisdiction has no legal or evidentiary basis, and a party who has not submitted to the arbitrator's jurisdiction is entitled to a full judicial review on evidence of an issue of jurisdiction before the English court. So my suggestion, Lords, and as I'll make that good, is going to be this: if we overexpand this doctrine, even if I have an Indian-seated international commercial arbitration, and the arbitral tribunal proceeds against a non-signatory, when I go out to enforce that award and there's a de novo review of jurisdiction by countries which follow the localized regime, maybe not in France, but there's a significant number of countries under the New York Convention follow the localized regime, the unilateral. That award is susceptible not to be enforced on the ground that there is lack of jurisdiction. So whatever interpretation that your lordships sets out today transcends three spheres: the sphere of the tribunal's jurisdiction, the sphere of enforcing awards outside of India, and take the case, say, of an Indian company, an Indian parent, a big trading house, say, taking sugar mills from UP, exporting it outside. It takes the call. It says, I'm setting up a subsidiary in Singapore, I'm setting up a subsidiary in the BVI, I'm setting up a subsidiary in Cayman Islands. It's fully entitled to that. That BVI company and the Cayman Island company enters into a contract with a Chinese company or Hong Kong company or whatever. There is a dispute. That arbitration award is passed against the BVI company or the Singapore company. Let's assume the Singapore company is a $2 company, but the Chinese or the Hong Kong company perfectly with its eyes wide open says, I will enter into a contract with the $2 company and I will, at the end of the day, have my dispute with the $2 company. Dispute is fought, dispute is lost. Can you enforce it against the Indian company in India? In my respectful submission, the answer is no, you can't. Because with open eyes, you, the foreign company, contracted with my foreign subsidiary. Now you fight it there. That's why Section 44 will become critical. New York Convention Articles 2.1 and 2 will become critical because this interpretation that your lordships give today will run across all these three tribunals, jurisdiction 2.1 and 2.2 and 44 of the arbitration.
Mr. Diwan, you are talking about enforceability. That's the emphasis now.
It's all three.
That's equally also. But
yes,
you see, just by applying the doctrine, we are not saying a non-signatory is being brought in. We have to also look at his intent, his conduct. Those are the parameters on the basis of which we'll apply the doctrine. I mean, just because the doctrine is, we adopt that this is a doctrine to be followed, it doesn't mean that we bring in non-signatory without looking into their intent and conduct.
Your Lordship is absolutely right. And which is why, one of my submissions where I point out to certain paragraphs in Chloro and Cheran and MTNL, which I'll tell your Lordships from practical experience, because we use all these judgments very often in international commercial arbitrations to either bring in a non-signatory or to try and move away from an arbitration, are used in a manner which, in my view, over-expand the jurisdiction of the tribunal. And since your Lordships is sitting in 5 today, in fact, one of my submissions is going to be that your Lordship should either clarify those parts or set aside or strike out certain parts of those decisions, so that it cannot just be a group of companies or single economic entity and nothing. It cannot.
It can't be nothing.
That's right. But there are parts of all of these judgments which are cited often and often enough, which become a
that, I mean, that's what lawyers' ingenuity is something which you cannot ever, curb.
Since your Lordships is giving clarity today, and I made that good, and I'll take your Lordship.
That's only a great aspiration that, judges can give clarity which will last for all times to come.
But
it's as good as the next lawyer with an imaginative mind.
Yes. But certainly your Lordships, in my respectful submission sitting here, should look at this aspect, which I think is important, because it has significant ramifications. And that's really the point I wish.
You seem to be suggesting that the omnibus expression of group of companies is not very precise. So go into expressions such as consent and other things is what you are.
Mutual intent.
Mutual intent.
Yes, please don't go by just the economic entity being the same.
It's like that, which have generally been.
In fact, I have suggested that your Lordship looks.
So concrete suggestions as you suggest, Mr.
Yes, in fact, that is set out in paragraph 27, and I'll come there. Let me just quickly run through paragraph 8. The very foundation of arbitration is
all consent.
In fact, we had this book, there's an entire Oxford University Press book on consent in international arbitration. We put this version of it here. It's not, I don't have it here. It says the principal characteristics of arbitration is that it's chosen by the parties by concluding an agreement to arbitrate. The arbitration agreement is considered the foundation stone of international commercial arbitration, as it records the mutual consent of parties to submit to arbitration, mutual consent which is indispensable to any process of dispute resolution outside international courts. Such processes depend for their very existence upon the agreement of the parties. Hence, this element of mutual consent is essential, as without it, there can be no valid arbitration. Under Indian law, such consent is typically required to be expressly set out in writing by means of an arbitration agreement, and that's a standard signatory legal doctrine. Now, my first submission is this: the group of companies doctrine and the single economic entity doctrine have no legal form and cannot be the basis for imputing consent. It is respectfully submitted that the GOC doctrine has no legal form. As set out in paragraph 8, these are my first skeletal submission. The GOC doctrine is a purely economic concept, which has no basis in either contract or company law. It runs counter to the principle of separate legal personality for companies. And this decision that I have cited, which is the Bank of Tokyo, in fact, it's Lord Gough's decision, whereas Lord Hoffman, then a lawyer, was arguing. And interestingly, your Lordship will find the same quote even in Mr. Khambata's submission. We just happened to have extracted it at the same time, where he says, Mr. Hoffman suggested begrudgingly that it would be technical for us to distinguish between parent and subsidiary companies in this context. Economically, he said, they were one. But we are concerned not with economics, but with law. The distinction between the two is in law, fundamental, and cannot be breached. And also that same book that we have, which is Consent in International Arbitration, what they've set out is this. The group of companies doctrine is probably the most prominent and controversial of the theories developed to extend an arbitration clause to non-signatory parties. Unlike other bases for binding non-signatory parties to an arbitration agreement, such as agency, alter ego, estoppel, which have their origin in contract law or company law, the group of companies doctrine was developed specifically in the arbitration concept. The treaty also carefully analyzes various countries and compares the acceptance or lack thereof of the GOC doctrine. My Lord Justice Narasimha, in fact, put that question yesterday. Is there a comparison? Lords, in this treatise, there is a comparison. Lords, it is part of the bundle of authorities that I have cited. Your Lordships Lords can look at it. It deals with France, Switzerland, England, and the United States. And Lords, talk about how and when it gets accepted. Now, the rejection of the doctrine as a basis to extend the jurisdiction of an arbitral tribunal over a non-signatory in Peterson Farm was also relied upon by the Singapore High Court and Manucher Steel at paragraph 75. Now, paragraphs 12, 13, and 14. I have extracted from the Singapore High Court's decision in Manucher Steel. Look, can I just take your lordship through that decision?
We'll go through this and then we'll go through the decisions.
Certainly. Yes. So, the rejection of the GOC doctrine as a basis to extend the jurisdiction of an arbitral tribunal over a non-signatory in Peterson Farms was also relied upon by the Singapore High Court in Manucher Steel, which at paragraph 75 observed that for now the import of Peterson Farms was that as a matter of arbitration principle, a tribunal has no jurisdiction to bind strangers to the arbitration agreement on the basis that these strangers are part of a large group under the group of companies doctrine. This was yet another example of how stringently the courts regarded consent to arbitration. Similarly, even the single economic entity doctrine has no legal form. In Manucher Steel, the Singapore High Court rejected the argument that a single economic entity concept is recognized either under common law or under Singapore law. In fact, observed in paragraph 92 that because the law allows and treats a company as a separate entity from its shareholders in the ordinary circumstances, it is perfectly acceptable in many jurisdictions, including Singapore, for an enterprise to be established and carry on business as a BVI company with the attendant advantages of non-transparency of ownership, management, and financial positions. Generally, a BVI company need not make public details of its shareholders, directors, or financial statements. That the shareholders of a BVI company are unknown or may not be identified through public means is not relevant as to whether a BVI company has capacity to enter into legal relations. Its capacity is derived not from its shareholders' legal personality, but from its separate and distinct corporate legal personality. Why any business person would choose to contract with or accept the credit risk of a BVI company without extracting a personal guarantee of some security is, of course, a separate matter. It has also been said under paragraph 96 that plainly the law eschews disregard of the separate corporate legal personality of a company except in exceptional circumstances and only where there has been some form of abuse. Respect for separate corporate legal personality of a company with the rights and liabilities attached to that personality is sacrosanct in nearly every other circumstance. So, in your lordship lifts a corporate veil, etc., etc. Those are different circumstances. Otherwise, separate legal personality is accepted. And if you've chosen to transact with the BVI company, then you've chosen to transact with the BVI company. And if your arbitration clauses with the BVI company or a Cayman Island company, then that's what you as a counterparty have chosen. Nobody is stopping you from going to court, which is the Section 28 argument which Mr. Kambata had raised. And we fully subscribe to that. But if your arbitration agreement is with the BVI company, and that's a separate legal personality, then that's where it stands, unless, of course, the other grounds are made out to bring a non-signatory in. Since neither the GOC doctrine nor the single economic entity doctrine can be recognized as ones having any legal form, they cannot be demonstrative of establishing any intent of a non-signatory to arbitration. So that's my broad basis. Now, as I come to the facets where I think where chloro, Cheran, MTNL, and ONGC, my respectful submission should be clarified, or I've said it. Let's just first look at paragraph 103 fluoro, which sets out two bases. I would say the conclusion, the basis by which you can bring a non-signatory 103. Various legal bases may be applied to bind non-signatory to an arbitration. 103.1, the first theory is that of implied consent, third-party beneficiaries, guarantors, and other mechanisms. This theory relies on the discernible intention and to a large extent on good faith principles. They apply to private as well as public entities. The second theory includes the legal doctrine of immediate relations, apparent authority, piercing of the veil, joint venture relations, succession, and estoppel. They do not rely on the party's intention, but rather on the force of applicable law. While there is no concern with respect to 103.2 of the law, where a legal basis is adopted to ascertain which is the real party to the dispute, to the extent that paragraph 103.1 seeks to bind a non-signatory to an arbitration agreement, and to a large extent based on good faith principles, it should be clarified that unless a court or a tribunal finds there to exist a discernible intention to arbitrate, a non-signatory should not be compelled to arbitrate. So, if your lordship just strikes that red part out, and it is that you must find a discernible intent.
You don't sort of read a passage in a judgment and then, identify, some portion. You read the whole passage together.
Look, I said, your lordship, so the problem.
Therefore, once we accept that mutual intent or consent are the key factors, how does consent or mutual intent get deduced? That's the point. Then to decide whether there was consent or whether there was a mutual intent, obviously you will have to look at various factors.
How do you?
And those factors cannot be decided with any specificity in advance.
And I'm not for a moment suggesting that. Please don't take it.
So therefore, you also accept that, well, mutual intent to arbitrate, consent to arbitrate, these are key because of party autonomy, because of the doctrine of severability, so on and so forth. Once we accept that, then in isolated observations and fluoro control, you're right, it may require a little bit of tightening up. But we can't just say, okay, they read these observations in red and therefore don't read the observations in black, which are not highlighted. Everything reads together ultimately.
I tell your lordship what the difficulty. When I have no difficulty with the broad aspect that your lordship said. Fluoro needs tightening up. And
there's no difficulty once these observations are in the hands of seasoned arbitrators. They know where to apply the law. They know what to. They don't read the judgment as a sort of, as something written stone.
Because I have more examples, 5 examples, and these are, in fact, Mr. Kambata and I, in many cases, been on the same side and been on the opposite side. I've been on sides where I have propagated a slightly overbroad approach. And these are real life examples of international.
That's the fun of lawyering, right?
That's right. But the fun of certainty.
You can never have certainty. It's the quest for certainty.
Fun of having certainty.
Yeah.
What I am requesting my lord to take this matter is bringing up.
Mr. Diwan, this point is very well taken, that consent is an essential part of it. But have you suggested that how to tighten it up? What are the factors which the court must take into account to decipher whether there is actual consent or not?
Yes. I will deal with that. That's a paragraph 27. It's a short, there is in fact a numerical decision, and I would
tell us
also come to dialogue. But can I just point out a few other paragraphs here which are really turning out to be the problem? Look, your lordship will look at reconciling paragraph 71 to 73 and saying, of fluoro, and saying, let's read it all together. But Lords, I can tell your lordships often enough that 73 is read as a silent paragraph. And in my respectful submission, the way it also was founded in Cheran, seemed to suggest that what was accepted was a 73 was a silent. And 73, in my respectful submission, is the problem, because what 73 says is as follows. A non-signatory or third party could be subject to arbitration without their prior consent, but this would only be an exceptional case. The court will examine these exceptions from the touchstone of direct relationship to the party signatory to the arbitration agreement, direct commonality of subject matter, and the agreement between the parties being a composite transaction. So 3 facets which can be used to say, well, without consent, we can bring you in. The transaction should be of a composite nature where performance of the mother agreement may not be feasible without aid, execution and performance of the supplementary or ancillary agreement for achieving the common object and collectively having bearing on the dispute. Besides all this, the court would have to examine whether a composite reference of such parties would serve the ends of justice. Now let's please see how under these three facets it becomes so overbroad. One, the first three, which is relationship, commonality of subject matter, and composite transaction have nothing to do with intention, standing by themselves. Two, performance. And there, paragraph 76 becomes a bigger problem. And three, does it serve the ends of justice? You may well take that view when your lordship is sending when your lordship is sitting in court. But when it's an arbitration agreement and someone hasn't signed it, and you haven't chosen an institution which allows for consolidation or joinder, when you're sitting ad hoc, can you just bring in a party? Because if I say take the ICC rules, or if I take the SIAC rules, or if I take the MCIA rules, or the DIAC rules in Delhi, and I can choose any of these, there's a provision for consolidation, there's a provision for joinder, which means I have consented to consolidation, I have consented to joinder. And in those circumstances, yes, multi-party disputes may well be joined together, but there is consent by accepting a set of rules, but not in an ad hoc situation. And that's really where 73 then becomes tricky, because it leads to greater uncertainty. And 76, and the reason why I say it becomes a bigger problem, is that when it talks about the mother agreement and subsequent agreement, it has a fundamental bearing on interpretation of contracts and the point of time you decipher intention. Let me just read out 76 more and then highlight the two problems. Paragraph 76, Cloro reads as follows. The court will have to examine such pleas with greater caution and by definite reference to the language of the contract and intention of the parties. In the case of composite transactions and multiple agreements, it may again be possible to invoke such principles and accepting the pleas of non-signatory parties for reference to arbitration. Sorry, that's from the second sentence, it should have been in red. Where the agreements are consequential and in the nature of a follow-up to the principle of other agreement, the latter containing the arbitration agreement and such agreements being so intrinsically intermingled or interdependent that it would be their composite performance which shall discharge the parties of their respective mutual obligations and performance. This would be a sufficient indicator of intent of the parties to refer signatories as well as non-signatory parties to arbitration. The principle of composite performance would have to be gathered from conjoint reading of the principle and supplementary agreements on the one hand and the explicit intention of the parties and attendant circumstances on the other. Both paragraphs 73 and 76 are inconsistent with two fundamental concepts. 73 permits a non-signatory to be roped into an arbitration agreement merely on the basis that there is direct commonality of subject matter and the agreement between the parties constitutes a composite transaction that is insufficient to justify consent. 76 is inconsistent with the basic principle that intention of the parties to an agreement must be determined not only from the text of the agreement, but also from the date of its execution. If on the date of its execution there was no subsequent agreement, then it would not be envisaged that an arbitration clause in a mother agreement would bind a subsequent agreement unless so expressly provided. That's when your doctrines of incorporation, etc., will come in. Because if I have signed an agreement on the 1st of January 2023, and it's a long-drawn contract, and I sign another agreement on the 1st of January 2024, and that either has a separate dispute resolution clause or has nothing. From a contractual interpretation perspective, how can you say that your mother agreement, which is 1st of January 2023, envisaged that subsequent disputes in a subsequent agreement would be covered by that agreement? That could never have been the intention of the parties unless it was expressly provided for. Saying all future contracts or all disputes arising out of future contracts will also be a part, because it's a separate contract. And it happens. There have been many cases like this. And Cloro was a case like this because in Cloro, the finding is subsequent agreements. Disputes under subsequent agreements can come back to the mother agreement. And those, as your lordship recollects, in Cloro had their own arbitration process. How could that be the basis to decipher intent? Because when the mother agreement
we get that point, Mr. Divan, that point is well taken. You don't need to labor on that. all those passages in plural and subsequent, the point is well taken.
I'm sorry.
You have understood your point. Now, move further.
I will.
Tell us, which is the method, what is the method? What is the process by which
Yes.
we would arrive at the actual consent
certainly
that you are
go through that.
propagating?
Very
I
good.
Go to your
para
para
28,
31,
31,
28 and 31.
Very good. So let's, I will skip.
Let's go to,
I'll let me skip a couple of paragraphs. So it's 21.
We see
now come to 28 is where you quote
28
red
where you
fern.
start actually.
So 21, 23, 25 words, in my respectful submission, point to
Same thing.
the same kind of problem.
Same thing. Same thing.
Just one greater concern which arises from the ONGC. Just look at para 25 of my submission, where your lordship
That these paragraphs allow non-signatory to be bound without consent would make them inconsistent with the fundamental facet of arbitration, can only be resorted to with the consent of the party.
And it's that little part that I wanted to refer to from ONGC, which is problematic in my respectful submission rules, is that paragraph 30 of ONGC, where it is said, it noted that written intention to arbitrate between parties can extend to bind non-signatories with the aim to target the credit-worthy member of the group of companies.
This is what red fern says, which you have quoted yourself.
I have.
Then exactly, and we have referred to red fern, we have quoted red fern there.
That's why I'm not from saying, I'm not from.
See, where you have referred to red fern
I
yourself.
certainly have.
Red fern expressly refers to what is the purpose of the doctrine.
That's right. Now, paragraph 27, your lordship is absolutely right. I have referred to Redfern and how Redfern reads down now.
That's right.
And what Redfern effectively was a paragraph 27. I mean, what I've said out of paragraph 27 says this. Read Dow as being a group of companies doctrine. Read Dow in what it really should be.
Thou for us is not the statute. Correct?
Not just a statute, but
In other words, go by section 7.
In fact,
what the law is.
and in fact, at page 11, para 27, 2.54.
I've highlighted that.
According to the Dow chemical case, may perhaps be best characterized as authority that conduct can be an expression of consent, and that among all the factual elements, the existence of a group of companies will be relevant.
I'm so deeply obliged. I'm so deeply obliged. That's what I highlighted to your lordship's time consideration. Now, your lordships has all of these judgments. Your lordships has Redfern, which I have quoted notes and instance of. But am I asking your lordships to just simply subscribe to what is set out in Redfern? And my respectful submission was just because there is a little balancing that's required. And that balancing is what I have set out at paragraph 28. And there, Manoj, I will
Now go to para 31.
Yes, can I-
That's where your 2 points which you are making. How to really then infer what kind of conduct and what kind of consent or implied term.
Because one is that, and then towards the conclusion, Namrata, I give you a lot of stuff. Because can I read out 20? Because there's something critical there. Because there's a little balancing that's required. It is respectfully submitted that the evaluation that is to be conducted.
There is a
Para 20.
That this is the evaluation to be conducted. The presumption must be balanced. So these are the presumptions which have been drawn by Redfern, with the equally compelling fact that the party who has negotiated a contract have deliberately chosen not to be bound by the arbitration agreement by having the contract executed through a subsidiary or a sister concern. The action of stepping away and limiting liability may well form the basis to demonstrate an intent not to be bound by the arbitration agreement, which at the point of execution of the contract has been accepted by the party. And that's my point. When your lordships has doctrines such as...
But therefore, are you saying that basically no party which is not a signatory to a contract can be bound by the
No,
arbitration?
there may be circumstances where you may have accepted,
Obviously.
where you may have written, but today, if there is no such, don't just look at your lordships to balance the evidence. If there is no evidence, suppose I have negotiated the contract, but finally signed by my BVI subsidiary. The counterparty has been perfectly happy executing the contract with the BVI subsidiary. I have, using my group structure, shielded myself. Am I not entitled to do so as long as the counter? Why should that? I'm the sugar. Of course, it's family. But it's a high-sea trade happening with my BVI subsidiary. It happens all the time in India.
So precisely, Mr. Diwan, party or a group company can arrange their affairs in a manner that I consent to move away from this particular part. This is what you are trying to say.
That's correct.
So we are talking about determining the consent. Here we can easily see there was to move away.
Yes.
So that is what we have to sort of focus on in a situation.
That's right.
When affairs are arranged in that way.
I'm so deeply obliged. What is by reading all of these decisions? I can tell your lordships with some amount, with some experience that I have in this, that these decisions are being read to say it's a composite transaction, you're performing the contract, that's only a subsidiary, you're roped in. That's the concern. And nobody is looking into the fact that, yes, of course, I may have negotiated, but I stepped back and you perfectly well agreed to allow me to step back and step out of it.
Para 34.
Yes, let me straight away come there. So now the test.
34, 35 and 36 you have laid down.
The test you're looking for,
Yes.
what you're suggesting.
That's
is
it.
that-
So look, the test that I am suggesting derives itself from various one looks from a US decision which was set out in the consent to arbitration, which effectively says there must be a clear and unmistakable intent to arbitrate. And also this must be from a dispute resolution perspective, from the doctrine of separability perspective. And what is also set out by Dalla in the concurring opinion of Lord Collins at paragraph 122, where right at the end of paragraph 30, what your lordships will see the last 4 lines, it would have to be a conscious, deliberate act by the government. That anything less deliberate act of the government make it less relevant. This was the government of Pakistan, and the letter would not be relevant.
Para 31, there's two tests.
That's right. I set out in the additional skeletal submission, the paragraph
Just keep
7.
one there.
I'll come to that. The conduct of the non-signatory party demonstrates to be found by the arbitration as a separate document, as a separate contract, saying my disputes you will be arbitrated. And in incorporation of an implied term in a contract where a non-signatory is implied to be a party to an arbitration agreement. These are the two bases which, if clarity is brought out here, will make it significantly easier. And these are exceptional circumstances. If there is something which meets the NABA power penta test, and you can get me in, get me in. But if you can't, then you can't. So these, and
Now see para 34, 35, 36
Yes.
is important actually.
that's it. So look, how I have now distilled section of the Arbitration Act is as follows. I'll just read out the first part of section 7, which says arbitration agreement. In this part, arbitration agreement is an agreement by the parties to submit to arbitration all certain disputes which have arisen or between them in respect of a defined. Now, I divide that part of section 7 into 2 parts. There are 2 parts of section 7 of the Act. I'm reading paragraph 13. The first of which is the agreement by the parties to submit to arbitration certain disputes. So that's the first part. The second part of section 7 relates to the manner by which such disputes will arise under a defined legal relationship. Now, in these proceedings, binding a non-signatory to an arbitration agreement ought to be considered the first part of section 7, which is whether there is an agreement by the parties to submit to arbitration. It is only on the conclusion of such inquiry that the basis and substance of the dispute which may have to be arbitrated are required.
So,
So that's how I break section 7. And what I also further submit is that it is, paragraph 35 is that the definition of party ought not hinder your motives. Because a party, I will say, should be the real party. Because 2(1)H says unless the context requires otherwise. So your lordship is not bound by just the definition as it stands. And therefore, the paragraph 36, I say, if in a particular case it has to be asserted that the real party to the arbitration agreement is a non-signatory, then the definition of 2(1)H ought not come in the way of restricting the arbitration only to the signatory.
Now just let's see your conclusion, Mr. Diwan.
Yes, just a little point of claiming through and
Through and under which, okay, Mr.
that's right. I'm not going to repeat anything there. But please remember just one thing. When the section 8 and section 45 come into operation, I have filed a suit in India. Very clear. It can only be related to an Indian suit or any other Indian proceeding. A non-signatory comes claiming through and under, saying, why have you filed it against me? I am claiming through and under against this as a defendant. Send me to arbitration because there's an arbitration agreement with somebody who's a signatory. Certainly the signatory comes no difficulty. It's a direct 845F. Claiming through and under is actually a defendant's doctrine. It's meant for a non-signatory to come in and accept that obligation to arbitrate. Because the other person who has filed a suit says, yes, I may have a contract with person X. Maybe you're the assignee, maybe you're not the assignee. I don't know. Maybe you're the parent company. I can't go against it. I file a suit. Parent company comes and says, no, I'm claiming through and under my subsidiary. I am the real party. Send me to arbitration because your contract has. So look, it's a defendant's doctrine. And what I'm only saying is this. That defendant's doctrine under 8 and 45 cannot be used to just bring a non-signatory group of companies, which is where there's been a conflation in my respectful submission.
All right, let's go now to the conclusion.
No, I'll certainly now come to the conclusion. Look, and the point we make is this. It is respectfully submitted that this honorable court have to set aside parts of the decision in favor and subsequent judgments that allow arbitral tribunals to commence arbitration only on the basis of the GOC doctrine. The GOC doctrine cannot, without more, extend an arbitration agreement to a non-signatory. The determination of the real party to an arbitration agreement must be reflected on the execution of the arbitration agreement. This approach would balance the public policy between certainty of contracts as well as resolution of disputes and would not be antithetical to the development of arbitral jurisprudence. That is because there are other recognized doctrines on the basis of which multi-party disputes can be resolved under the broad umbrella of a single determination. These includes concepts such as recognition of a single arbitration through the doctrine of incorporation by reference, or in the case of institutional rules, providing for consolidation of disputes. As Hanashia notes, joinder and consolidation of disputes is an issue distinct from the issue of extension of an arbitration clause to a non-signatory, and therefore the policy considerations for the two mullahs should not be conflicted.
Yes.
And that is unfortunately what has happened with Chloro and the judgments which have gone down. But I want to answer one question which my Lord Justice Roy had raised, not today, but a couple of days ago. From a construction contract perspective, employer, contractor, subcontractor. Mr. Kambata had made certain submissions, which I adopt. But under the FIDIC rules of contract, which again internationally for contract becomes very, very rare. And I've quoted this. Article 4.3 says that the subcontractor has no privity with the employer. Now, if your lordship's lords under Indian law says, sorry, in such a situation, because of composite transaction, because at the end of the day, you subcontractor are only performing for a contractor who's performing for an employer, I can rope you in. Then it's going to be against the FIDIC rules for construction of contracts. So the construction industry, in my respectful submission, gets into a bit of a dizzy. Well, let's take international trade. The way companies are set up for international trade and commerce, again, provides group structures. And therefore, I would be very hesitant in accepting, as the other side says, Chloro in its entirety. And the judge.
Right. Thank you, Mr. Diwan. I think thank you very much, Mr. Diwan.
But I'm so deeply obliged. Well, all my references, I'll just take one. I'm not going to take a lot. My first skeletons and my additional skeletons, and these will make a reference to everything that is relevant.
Thank you, Mr. Diwan.
Because I'm so deep.
Anybody else?
I had just 5 minutes.
I appear for,
Yes.
But do I have 5 detailed?
Where were you all through?
I also appear for respondents number 1 and 2.
How will you be able to argue? You don't have any idea of what has happened before you
have no idea.
matter.
No, I've been watching the proceedings.
We wouldn't have missed you.
You are watching on the virtual mode or physical mode?
But physically and as well as virtually, whenever I could not be here. I knew a lot.
What is the point you want to make? What is covered so far?
But I just made 3 charts if lordship permit me.
Charts, all right. Give us the charts.
But I just wanted to, my lord, just put some.
Chetan,
But I just wanted to, my lord, just place before lordship, just the elephant on the table, and this, my lord, unfortunately, I don't have solutions, but I was raised certain important issues, my lord, the lordship to consider. But one is, my lord, which fell from my lord Justice Narasimha on the very first date of the hearing, and which my lord the Chief Justice, my lord, picked up on the issue of my lord, parole evidence. That, my lord, common law jurisdiction, my lord, we go by, there is an aversion to parole evidence, and we go by what is the written document. And therefore, my lord, we come to section 7 of the law. Now, my lord, the difficulty comes, my lord, when we come to, my lord, 8, 11, and 9. Because the difficulty will be, my lord, that when there is certainty in section 7, that we know those A, B, C, D, E, and they are all written. It may not be a written signed document, but there are exchange of between parties, written evidence. One of the section 9 judge, section 8 judge, and section 11 judge has clear, my lord, evidence before it, primary evidence before it. Now, my lord, what happens, my lord, when you don't have that and you have to go beyond the world? Well, that is why the difficulty will happen, Malad, if this group of companies doctrine traverses beyond Malad, section 7. Malad, for example, in our case, my lord, it took 3 years and we suffered an interim order. So much so, my lord, there was a restraint on alienating assets.
So what would you like to, how do you formulate your submissions?
Yes, my lord. My first
points so that you can just take them down.
Yes, my lord. My first proposition, my lord, with lordship is free from the chart which I have given, the first chart. My lord, what the group of companies doctrine does is it conflates, my lord, two contrary concepts. If lordship sees the chart, my lord, I have given at the first paragraph, my lord, is called the which requires presence of wrongdoing, and the second column is absence of wrongdoing. Now, my lord, Professor Gary Bond calls the first one non-consensual, meaning, my lord, that there is not a requirement.
Why did you formulate it?
May I formulate that?
First proposition you were saying.
My first proposition is the group of companies doctrine conflates contradictory propositions of law and hence is unworkable.
Which are those contradictory propositions?
Please, my lord. My lord, if lordship has my first chart, the concept of alter ego.
The concept, we are taking it down now. The concept of.
Well, I can submit for me. I can give submissions later. The concept of alter ego, sham,
the concept of alter ego.
Concept of alter ego, my lord, is based on wrongdoing. And there has to be egregious fraud or some kind of sham, evasion, some kind of wrongdoing has to be there, my lord. And here, my lord, the intent is not so much as whether you're intending to be bound by the arbitration agreement.
All right. So
one is alter ego.
Alter ego.
Second,
sham, evasion of statute, facade. And my lord, I've given the judgments where my lords have in several cases explained this, including, my lord, the recent case in Balwant case. Lordships have, my lord, dealt with this issue. And lordships have explained, my lord, that it is not just having a tight control company or closely held companies. There has to be some element of fraud. There has to be some intent to avoid obligation or to defeat a statute or evade payment of tax.
All right.
And what Professor Gary Bond says that this is non-consensual, meaning that even if you did not intend to be bound by an arbitration agreement, if your intent was to avoid and evade, then you're still bound. And he, of course, applies the group of companies doctrine and says that in such circumstances also a non-signatory entity is bound by the arbitration process.
All right, there's the first proposition.
Yes, well, in contrast, my lord, lordship sees the other, my lord, commonality of subject matter, existence of group of companies, composite nature of contract, performance of contract, single economic reality. But these, what lordships have over time, my lord, etched out as attributes of group of companies doctrine, my lord, are all not based on wrongdoing. It's simple that, for example, my lord, in MTNL, lordship said if there's a tight economic structure, even if there is no wrongdoing, even if there's no evasion, even if the intention is not to avoid a group of companies, then you're bound. Now, my lord, the difficulty is, as I was saying, my lord, a section.
So what you're really saying is that the whole concept is intended to reach out cases of fraud, positive wrongdoing.
I'm obliged.
And,
I'm obliged.
these aspects which have been highlighted in chloro, they really are not based on wrongdoing at all. You may have a composite contract, you may have performance by one
Absolutely.
of the obligations of another without any
I'm obliged, my lord. I'm obliged. And if 7 is absent, my lord, if the 7 test is absent, you cannot bring in such.
We got that, yes.
That's all. Well, the second, my lord, related to this, my lord, and my lord, this is the issue. My lord, of course, my lord, I'm trying to pitch it at a level, my lord, I don't know whether Lordship will accept this. But what I'm submitting is that even with regards to, and my lord, this is where Lordship will have to reconcile, because I've given the contradictory judgments of all the high courts, my lord. Even when it comes to egregious fraud or alter ego piercing, my lord, Honorable High Court of Delhi and Honorable High Court of Bombay and Honorable High Court of Madras have taken contradictory views. Coordinate judges have taken contradictory views, and I've given the, my lord, the table in the third table. I will not read it, my lord. But that an arbitral tribunal, being a creature of a contract or with a specific remit, will not have the plenary powers of the court. Well, these judgments are post-competence, post my lord's chloro control. The learned judges are aware of all this. Yet they hold, my lord, that a court, an arbitral tribunal being of limited jurisdiction, cannot pierce the corporate veil, and that can only be done by a court of plenary jurisdiction. My lord, just to name a few judgments, my lord, in the Delhi High Court, my lord, I've given in the third chart, Sudhir Gopi versus IGNOU. My lord, Justice Bakru's judgment is there. And my lord, Bombay High Court Justice Gupta's judgment of NOD Bearings Private Limited, I've given as serial number 3, my lord, of the third part, my lord. I've just extracted these judgments. I didn't want to waste Lordship's time by going through my submissions, but I've extracted those parts where these the discussion is there, and the High Court says that it cannot go. The tribunal cannot pierce the veil. So my lords will have to reconcile this, and my lord, of course, Lordships will hold one way or the other that whether this group, I mean, I've given also my lord, the other judgments which I've held, they can do it. So my lords will have to, my lord, reconcile this issue. And my lord, the last thing I would submit, my lord, and which I was submitting on Vidya Drolia, and I'm done, my lord. In Vidya Drolia, my lord, Lordships have, my lord, made the it's not an exhaustive list, but Lordships have given certain exceptions to arbitration. Now, my lord, 2 exceptions, if I may, my lord, place for Lordship's consideration. My lord, one is when there's an adjudication at rem, or it has an effect at rem. And the other is when there is a statutory machinery provided for the adjudication. And Lordships have, in both these circumstances, it is out. The arbitral tribunal cannot enter into this domain. And my lord, I have given in that second chart, my lord,
First instance, in the case of in rem would be a probate.
I'm obliged.
And the second would be surface, where there's a example.
Deeply obliged. Or in my case, my lord, I would submit if Lordship considers the Companies Act. Because my lord, in the Companies Act, and I've given the sections in the second chart, all the provisions are there for inquiry and investigation into the character of the company.
Right.
Now, would Lordships, my lord, permit a tribunal, which is a creature of 2 parties agreeing to an arbitrator who may not be a trained lawyer? There is no, my lord, obligation. As Lordships said the other day, it could be a technician, it could be an engineer, an architect. Would Lordships say that the power which is vested in a tribunal by the statute of determining who is the controlling authority, or would that, my lord, be given to an arbitral tribunal? Ultimately, my lord, certainty, my lord, which is the issue. My lord, I'm obliged. I'm so sorry, my lord, I interrupted.
Thank you. Right away. That is enough. Thank you, Mr. Ghosh.
Can I have just
Yes.
a few minutes? I'm for respondent number 1 and 2.
But 1 second, where is George Potan gone?
Yeah, hang on.
There you are.
Yes, yes.
Are you wondering where you suddenly disappeared?
No.
You disappeared behind the scene, George.
My lords, I appear for India in IA number 69863 of 2023.
You appear for the National Coordination Committee
Of UNCITRAL. Having heard the arguments at length, now my lords have the benefit of hearing both sides, the views of both sides on the issue of group of company doctrine and arbitration and the various views across the globe. My lords, at the outset, I would just like to mention that ancestral does not per se have a group of company doctrine, but looks at non-signatories to arbitration, corporate structuring. This is what ancestral has looked at. The mandate of ancestral, that is the United Nations Commission on International Trade Law, encompasses promoting ways and means of ensuring uniform interpretation and application of international conventions and uniform laws in the field of international trade law, collecting and disseminating information on national legislation and modern legal developments, including law in the field of international trade.
You have a note? Give us
You're
a note.
reading?
I'll give a note after this, my lord. I'm just skipping most of it was already covered. I'll prepare a note with
So
comparative.
what is the, tell us, just formulate what your point is, George.
My lords, I'll just draw a comparison between the Indian Arbitration Act and the ancestral model law, the 2006 amendments to the ancestral model law, the reason for the amendments, and I'll also touch upon the New York Convention because the model law complements the New York Convention. And last point would be on arbitration without privity. In this regard, it's pertinent to note that the Arbitration Act of India is based on a model law, and there is reference to that in the preamble and in the statement of objects and reasons of the state. So the legislative intent is clear that the Indian model law.
So where does UNCITRAL stand? UNCITRAL stand on the group of companies doctrine.
My lords, the UNCITRAL has brought about the 2006 amendments to accommodate non-signatories to the arbitration. This I'll just.
Where do we get?
You're standing on the wrong side.
Sorry?
You're standing on the wrong side.
Well, I mean, it's non-signatory is not on a group of companies doctrine. That's why I said it's. I mean, neither here nor there. But I'll just put it across what exactly it's.
I don't know how many countries have accepted the 2006 amendment.
Yes, I'm coming to that. Like.
Mr. George, why don't you give us a note on this? Because
I'll give a note on this. I'll just quickly go through the.
Because that will be better. You know, we'll be able to then see how it has evolved.
Yes. Yes.
But perhaps you have prepared a note which also takes into account other this thing, but so you can just consolidate and, sort of reduce the note and then give it to us.
Yeah, a lot of it was a repetition of what.
That is what we're trying to avoid that. So in your note, just delete the part which have been covered by the others.
Yes, yes.
And
Right
focus
now,
on UNCITRAL.
and right now, just sort of formulate your points. And
Yes.
You can give us a note. So just in 2 or 3 points that you want to make, you can tell us. Take it down.
Yes.
So
Is there
what's
any
the first-
suggestion that you have or any idea that you would want us to know? Just you can tell us that.
Yes. It's page, if your lordships could have volume 1 of my compendium, page 33.
Just formulate it, George.
Yeah, I'll just read this out, my lords. It states the reasons why the amendment was made. Article 7 was amended in 2006 in order to respond to concerns voiced by an increasing number of scholars, practitioners, and judges who were of the view that formal requirements set out in the original version of Article 7 should be amended to better conform to international contract practices. It was pointed out by practitioners that in a number of situations, the drafting of written documents was impossible or impractical. In such cases where the intention of the parties to arbitrate was not in question, the validity of the arbitration agreement ought to be recognized.
George, you put all this in the note.
Yes.
Make it a short 3 or 4 page note and give it to us.
Yes.
We'll have a background of why the 2006 Act model law, why the model law was amended in 2006.
Yes.
How many countries have accepted the broadening of the definition
Yes.
in the arbitration agreement?
And yes.
You can give it to it.
If
Let's
I can
call
just-
upon the other side so that you can.
If you can just touch upon 2 points and just on the arbitration without privity, because I mean, Dhala and those chemicals have been dealt at length. So I'll not touch upon that once again. But on Article 7, my lords, if I could just quickly have it's.
Now we are in.
the article
George, give us a note. Just give us a note.
Sure.
Very, very, very brief. I am for respondent number 1 and 2 in 5101.
Ms. Arora, you're on the right side, right? George was on the wrong side. I hope you're on the right side.
I am on the right side. I am.
Right side in the sense that you are supporting the group of
I
companies.
am completely supporting the arguments that have been advanced by the learned Solicitor General and Dr. Singhvi. And I support the principle of group of companies to be read in. I only have a very, very brief, let me just make
Tell
the
us your
points
point.
very clear. My lords, first of all, I have heard whatever I have gauged now. All these matters, Mr. Devan has appeared for respondent 9 in 501.1. I believe Mr. Darais Kambata has appeared for respondent number 8 and Mr. Ghosh for the petitioner. Now, what's significant in this matter is that this matter does not arise out of section 11, it arises out of section 9. And section 9 is very distinct and different from section 8 and section 11 because section 9, while the court may have applied the principle of group of companies to pass an order restraining the parties because of the very nature of the contract, but section 9 principles are entirely different from that of 8 and 11. My lords, by various orders, it has now been held that third parties can be joined in the matters of grant of interim relief, protection and preservation, before, during the arbitration and also after the award till such time as it is executed. So therefore, the arguments that have been advanced, and I believe it was suggested by my learned friend that the issues are different and should be detailed. I only want to put this on record, lest the final order deal with setting aside the interim protection granted by the High Court. My lords, I have placed the judgments under section 9.
So, which is your matter? This has to be dealt.
My lords, this is McLeod Russell versus KKR India, where everyone seems to have addressed an argument on 8 and 11.
You will not refer.
My lords, it is
501.
it's 501.1. It's 8607 of 2022.
The most we hear, we will take it that arguments were addressed on the general.
That's right.
reference. You're not going to-
We are not going
I am
to.
grateful. My lords, I needed that clarity.
Just before the
That's
regular.
all, we are not going to.
I needed that clarity to be in because I didn't want to be faced with an order suddenly setting aside an
no.
interim protection.
We'll not
Now
be
my-
deciding individual cases.
Yes.
Ms. Arora,
Now, my
you
lord,
made that point.
come
Mr.
to-
Kambata, in fact, clarified that we were only arguing on law. And
Very well.
all of us have been only arguing on law. None of us have really gone, I mean, your lordship haven't even touched the facts in McLeod.
Now, my lords, coming down to very, very briefly, and I will just take about 5-7 minutes of my lord's time and no more, because most of the judgments have been read, and I'm not going to read it except to the extent it may be absolutely necessary. My lords, the entire principle of group of companies is based on an aspect of, as my learned friend argued, is protection holding companies, subsidiaries, etc., which may be within the group. It is well recognized in the matter of corporate structuring that very often there are companies which have no or little assets, and a holding company may be the one which will hold all the assets, and they may be only leased to the subsidiaries, or it may be vice versa. And that is to ring fence and protect yourself from the arm of the law in the event either the subsidiary or one of those group companies gets exposed to liabilities. That is a principle my lords will find in respect of structuring of the holding companies or the group companies very well settled, because the idea is a protection.
Argument has been that, look, short of a case of egregious fraud,
Yes.
these are structural arrangements which the law does recognize.
I have no issue with that. They may be done for the purpose of taxation, they may be done for whatever reasons, ring fencing, protection. I'm not on that aspect at all. But I only want to restate the principle when I show the judgments, whether it comes from Chlorocontrol, Chevron, MTNL, and the last one in ONGC, that the court reaches out on what was your intent, as it was argued just few minutes earlier, was it your intent that I'm not going to allow an exposure of my assets into this contract, or did you conduct yourself in a manner which was representative to the other party entering into the agreement that yes, the other companies within the group will stand for the liabilities, obligations under the contract. That will be the test. And in that context, if we start from Chlorocontrol itself, if my lords, may I not take you to the judgments? If my lords have the written submissions filed by my colleague, I just want to show those few words. March by Apur Shukla.
Yes.
501.1. And therefore, if I have that context clear, each one of these judgments only signifies that what will be that nature of conduct, intent, reflected from the facts, which will bring the group companies into the purview. Fellows, we say a lot about non-signatories to be taken out. The principle is that each one of the judgments says non-signatory group companies. So the question of signatory does not arise, because if they were signatories, they were automatically bound by the contract and the arbitration provision. Because they are non-signatory group companies, therefore the various principles have been set out in each one of the judgments. Just few minutes and I will satisfy that. My lords have my submissions. Would my lords turn to page 17? First of all, Chlorocontrol. I'm only going to read few lines and few words and phrases in them, because my lords have already read these judgments extensio. I'm not going to take again that. My lords have page 17.
Yes.
This is a part of paragraph 72 at the bottom of the page. This evolves a principle that a non-signatory party, now my lords may mark the word, first of all, we are understanding that the party is a non-signatory, could be subjected to arbitration provided these transactions were with group of companies, and then my lords, the principle is set out in Chlorocontrol with great detail. Please remember the principles on the holding, subsidiaries, assets to be there or not available. Clear intention of the parties to bind the both. So therefore, first thing that the court will look at, was there an intention? What are the factual backgrounds to establish that intention? Both the signatory as well as non-signatory. In other words, intention of the parties is of significant feature. So the principle that the court said was intention. Now, my lords, please, page 18. 3 words in 103.1. The court sets out these principles. So these principles have actually been laid down. The first theory is that of implied consent. So the court will look into the facts to see whether there was an implied consent. Did you participate in the negotiations? Did you make representations at that time that yes, this will be done through our subsidiary? Are there back-to-back contracts where you took a subcontractor to execute your contract, but he's not a party to the main agreement, etc.? So, my lords, we have to look at each one of them. Next, third-party beneficiaries. Simple classic example in 501.1. A loan of 100 crore each is advanced to two companies which have no assets. That loan, they are only the companies which take the money and pass it to the other group companies. So those two companies take 100 crore each from respondent number 1 and 2, pass it on to their other two companies. Now, there are orders which have been there, representations made. Those companies will not pledge their shares. Those companies will not alter their status as being into public listed company. They shall maintain their EBITDA, etc., etc., etc. Who has made the representation? The parties that hold 49% odd shares in those companies. My lords, this is a conduct, this is a beneficiary, this is an implied consent, guarantors. Assignment and other transfer mechanisms of contractual rights. So this is the principle that Chlorocontrol said, we will look at these factors to see whether these non-signatory third parties are assenting to will be parties to the arbitration. Now, my lords, very quickly to Charan, if my lords may come to page 19. Would my lords just come to the highlighted portion? In holding, my lords have that, in holding a non-signatory bound by an arbitration, the court approaches the matter
These are extracts from.
My lords, yes, these are paragraphs. What I am only trying to establish before the court is that each one of these judgments set out a principle or a circumstance where it believed that in these particular fact and circumstance, a non-signatory group company would be amenable to be joined as a party to the arbitration, whether it was Charan or for that matter MTNL and subsequently ONGC. And in each one, my lord, different principle or a test which is laid down. Like, may I just quickly?
It's there.
It's there, we don't need it.
We have looked at these judgments.
Yes.
And we'll also note here that this particular matter 9, NHS section 9, no question of detagging because we're not going to decide it on
That's
this
right.
at all.
But in fact, that submission was made and
Yes, that's right.
none of us have touched the facts. Because in fact, we've been very conscious not to touch the facts.
Yes, yes.
We have your written.
Other submissions are there.
So, my lords, that is my principle in terms of understanding the principle of a
Right.
holding subsidiary,
Right.
management of ring fencing, protection. Then what
Right.
are those aspects that the court will look into? My lords will find it here. The only judgment that hasn't been set out here is that of ONGC. Yes, yes. And my lords, in ONGC, I would request my lords to look at paragraphs number, just give me a moment, my lords, page 283. Because principles in all these have been set up. ONGC.
Tell us.
Yes.
Para?
My lords, paragraph 37 onwards until 41.
Okay.
Para 36.
And those same principles have been then culled out as to where you would then have a non-signatory third party joining in an arbitration. So, my lords, to say that section 7 requires it in writing, etc., the principle is entirely different. In what circumstances would you have the non-signatory party?
Thank you so much.
Now,
Uh,
and my lords, the only other thing is that this particular reference will not apply in case of section 9 because I'm
That
not.
you have already
that you have said.
Not
Please
under
clarify
that
now.
principle, it's entirely different from 7, 8 and 11.
Yes. Thank you.
Great.
Ms. Dr. Singhvi, how long will you take?
It's your lordship has a special bench at 2:55. I have to finish before that. I'll finish. The lordship has a, not that this work will expand to fill the time available to do it. I actually have more time. I need more time, but I'll finish before your lordship's bench.
Lunch. Just broadly, what is
Yeah.
your submission going to be, Dr. Sri?
It'll be faster if your quartermaster can put three things. One is my note, which I gave you Lordship in the opening. Lordship will call it note one. One is a rejoinder note I have given now, which is a pointed one. Argument this, answer this.
Right.
Argument one. And third is CL1. That is case law one. There are also case law 2 and 3, but these three will cover 95% of my note. So my argument is simple that your lordships has to really ask two or three basic questions. I'll take only a minute, your lordship is rising. One, well, as I say, the life of law is not logic but experience. So, well, if your lordship were to go strictly by logic, your lordship cannot have anybody not signing going to arbitration. That's the correct way to look at it. Now, obviously, that's not what your lordship is going to do with justice. Where is the intent? Second error, only wrongdoing will display my intent. My learned friend says, where is wrongdoing positive or negative, you will send it to arbitration. Can't you have an intent to go with your sister concerns, group companies to arbitration without wrongdoing? Third, well, if the shield is made to, as they use the word ring fence, then well, if your lordship applies any of those 10 tests and finds A, that there is fragmentation, your lordship finds that the entire intent to settle the dispute or arbitration is frustrated by two companies being out because it is ring fence. So your lordship's doctrine is a superimposed doctrine which goes, of course, to the true intent, but along with intent sees all the other intent tests which have already given. That's good to you, I brought it.
Yeah.
I'll proceed quickly.
After
minutes. I'll proceed quickly to give a few minutes to
Yes.
Advani and
Yes.
I requested Dr. Singh that one part of Ms. Arora's statement, because she's here for the first time, one aspect I need to respond to, I need about a minute, not more.
now, so therefore, Lordship will have these three things open: my original note, my rejoinder note, and my CL1, which is case law 1.
1 minute, Dr. Is also rejoined.
Which was circulated earlier today.
And one list of authority volume 1.
List of authority volume 1 I got. Yes, we joined the submissions also.
Written submission is second last.
We joined the submissions. Volume 1, right? Yes.
Each of my lords has got that. Yes. Yes. Now let's. I've got about half an hour, so I'll be very pointed. So they have about 10-15 minutes left between them. Please see the larger issue for a minute, and then I'll read only some part of these two notes.
The rejoinder one? Which one you want us to take first?
No, Lordship may have all three open. I'm not going to follow this sequence, because I'll just go between rejoinder note, my first note, and CL1.
Yes.
These three things are 95-98% of my solutions. I'll take a different sequence to make it shorter. Right, Willis? Now, my opening point is, Willis, that Willis, if your lordships were to go by this, what I call the absolutist theory of signatory or Willis party in that sense, then your lordship must throw out completely the doctrine. If not, then the best your lordships can and perhaps should do is to consider where the existing law needs trimming or safeguarding. That's point number 2. Trimming is a more appropriate word. Why, Mills, I say trimming? Because according to me, my lords has already fleshed out 10, 12, 15 legal principles, which ring fence that doctrine already from abuse. Now, certainly to the extent my learned friends on the opposite side tell your lordships that this doctrine ring-fenced by these 15 principles needs further tweaking in this particular sentence, I am with them. I have no problem. But the problem with this case is they have not told your lordships that. They are suggesting again and again, by creating an apprehension without telling your lordships which of those safeguards needs tweaking, so as to actually reduce the doctrine to vanishing point. So, without telling your lordships, because they know they can't say that, they can't tell your lordships normally, please throw out the group companies doctrine. Actually, that is a logical thing to say on their side. Realizing that that may either be unpalatable or discretion is the better part of valor, they say, no, keep the doctrine, but put so many unknown conditions which reduces to vanishing point, which another way of saying throw it out. One of those points is, must be positive or negative wrongdoing only. Only an example, I'll be reading in a minute. Take, for example, the repercussions of that point. That means that absent even piercing the veil is not merely based on wrongdoing. It's a misrepresentation to your lordship to suggest that piercing the veil is based solely on wrongdoing. My lord pierces the veil in a wider set of contexts. But well, that would mean that your lordship will either equate the group doctrine only with piercing the veil. It's not the way it is put by the other side. It amounts to that. So, please ask them which particular safeguard, and the lordship is to be reminded of those 15 safeguards. Please ask them which of these safeguards is not enough, in what manner. That's a constructive exercise. I would join them in that. But absent that, please don't let it be reduced to vanishing point by a circumvention or a camouflage. That the doctrine is okay, but in some unstated manner, don't apply it to a non-signatory or to a non-party, which means there is no doctrine at all. Now, with that backdrop, please turn to 3 portions in a different sequence. First, turn to my rejoinder note, the last page. I'm following a little different sequence, it will be quicker. But remember these 3 points, which I said in the opening. With that backdrop, kindly turn to the last page of my rejoinder submission.
Para?
The very last page, it's a kind of an appendix. It's not a para. Does it have the title, test for recognition? Yeah. Now, what I've done here is I've done the reverse, and I think you'll actually find it useful. I have put the test or the concept and then the case law under it. It's already there, but I've done the reverse. Now, just give me a few minutes. I'll not read a single case on this page. One test is intention of parties, commonality of interest necessary to bind non-signatories. First of all, as my learned friend Miss Arora also said, I said in the opening, this non-signatory is a complete red herring phrase. This phrase non-signatory actually has no place in this jurisprudence. I'll tell you why. Because if you're a signatory, the doctrine doesn't arise. It doesn't arise. Then you must have an all or nothing. The moment you are not a signatory, the doctrine doesn't arise. Full stop. Your lordship throws out whatever your lordship wants to throw out. So the whole doctrine is, yes, a non-signatory can be there to what extent?
Express party, implied party.
Implied party. Now, so non-signatory, of course, we are using in the jurisprudence, so it's okay. It can go along, but that's the concept. Now come to this. Intention of parties, commonality of interest necessary to bind non-signatories. Now let's just see, these are chapter and verse specific paras where my lords has in 3 judges, 5 judges or 2 judges laid it down. I'm saving time to specific paras pinpointed. And I'm grateful to my learned friend, Mr. Himanshu Mehta, for having done that exercise under my supervision, but it's useful to have it called out. And I've got CL1. Which is your lordship's volume 1, otherwise sometimes CL2. Now, so many times your lordship has done it, the question your lordship should ask is, what is the imperative necessity of throwing out this whole page? Because if your lordship really were to apply the true test, then your lordship should throw out this page. Reverse this page, overrule this page. Now see the next test. Alter ego piercing of corporate veil may be required. My lord has given reasons. My lord has had in 2, 3 and 5 years and given reasons. Now, unless something compellingly wrong is shown, then all this should be overruled. Then, engaged in negotiation of performance of the commercial contract. Well, actually what happens is, this answers both the shielding point and the wrongdoing point. Well, your lordship does look for the intent. Let me give a nuanced answer to the point. Of course, your lordship goes by intent. But intent is both a subjective and an objective test. It's not a subjective test where I tell your lordships, I know I'm fully involved in this contract, but I will create a structure whereby, despite my full involvement, I will say my intent is to shield myself from arbitration.
As one of the cases said,
that your lordship's objective test kicks in. Your lordship is the judge there.
As one of the cases says, that you deduce the subjective intent of the parties from objective facts.
That's my next sentence. Therefore, the subjective intent test alone is constitutive of great injustice, and then your lordship must overrule the doctrine. What your lordship has never done is know or yes are black and white. My lordship has operated in the zone of grey. Otherwise, why does your lordship have these 15 principles, Minister? Because your lordship knows case by case justice can't be done without these 15 principles. Otherwise, lordship says, yes, we accept it fully or we don't accept it at all. No, your lordship says we accept it, but family-run companies through complex structure is one test. Yes, we accept it, but tight group structure with strong organizational financial links is another test. That is the right way to do it with respect, because your lordship will then be doing justice without straitjacketing it in an exhaustive manner for unknown speculative situations in the future, which your lordship can never predict. Lordships can never predict. Does your lordship want that injustice on a logical application of the other side's case? My respectful submission is answer has to be no. Yes, if your lordships can be pointed out any major fallacy or error in this page 6 principles I have given, then your lordships can tweak it. Has anybody told your lordship specifically in what language to tweak it? With great respect, I ask that question of myself. Not really. Either it's a throw the baby out of the bathwater or say it in a generalized way without telling us which principle is wrong here. And that subjective objective is very important for the Chief Justice also, Justice Narasimha. If your lordship were to give extreme and dispositive, conclusive weight to subjective intent, then really your lordship is saying every non-signatory is out. Because the intent of the non-signatory is not to be bound. Then why have a signatory, why have a doctrine at all? It is already that your lordship's objective intent kicks in and balances the subjective intent. But it has never been the absolute subjective intent. My lord applies the mind that objectively the whole system is there. Just because he has ring-fenced or created a structure, we will not leave our adjudicatory job of injecting some objective intent to do justice. That's the real crux of the matter. So, as I leave this page, my 2 or 3 takeaways, if I may use the word, is 1, would your lordships have any compelling need shown to your lordships by the other side to overrule this page? Is question number 1. The lordship has jurisprudence, the lordship has case law, the lordship has decisions. There must be something shown why the constitutional bench. I'm not saying lordships can't do it, but really many or all of these should be overruled. And certainly, because I find the compelling need, if at all, is the opposite side, not this side. The second takeaway from this page is that, I'm sorry, my apologies. As well, and friend adds rightly, that to 10 years after chloro, your lordship is celebrating the decade of chloro. So your lordship should overrule.
10 years after, just a thought. I think we haven't yet come across a critical mass of contradictory views in the context of chloro control principle. It's perhaps a little too early. As you are saying, that there are another set of cases which had proved to the court that this doctrine is excessively applied or overarched or wide enough, so much so that the court should take a step back and control. We haven't yet arrived at that situation, is what you're saying.
I'm extremely grateful, and may I, with your lordship permission, adopt that phrase, critical mass. That is the critical phrase. It is possible for a constitution bench which finds a predisposition of a mass of cases this way and that way, that is either equal or heavily weighted against the chloro doctrine. It is possible your lordship reaches a critical mass sometime in the future. Otherwise, really a constitution bench is being asked to do an extraordinary thing. And again, it is left unstated by them because they know if they put it like that, lordship would find it unpalatable. So it is not put like that.
To be fair, they have not put it at that level.
That's my problem. They have not put it, actually they mean that level. Exactly what my lord. That's my submission to your lord.
Right, you are saying that.
The consequence inevitable is that. That's the point.
But they have not brought forth, as Brother Narasimha said, the critical mass of evidence.
Let's just look at this critical mass phrase, very important phrase. Your lordship has got most of the cases actually on this chart. I mean, there will be 2 or 3 missing, but most are in this one page. Well, the interesting thing is that the critical mass is leaning in favor of chloro. So what is the constitution being asked to do? It's asked to create a new status quo without showing that the existing status quo has run amok. Without demonstrating in any reasonable way that the existing status quo has run amok. For example, your lordship has some judgments. I'll not name them as the old times, etc. I mean, one I can name as I argued Balco, private with Bhatia. The lordship has evidence that international commerce was being affected. There's a whole UN cry. But chloro, these judgments have been controlled. They've been actually very calibrated, very careful, cautious. They've not gone overboard.
You get the point.
This is the
What's
now, the second aspect is, come to my first note. Section C. Well, just stop for 30 seconds on section B. I formulated the 2 issues. We must remember the origin. These are the only 2 issues. In my B.1, this is the first note, the opening note. I'll not read it, Lordship knows. This really should be a Lordship's broad guiding pole star, these 2 issues. And none are made out in favor of the other side. Whether the acceptance, etc. of the group doctrine by several elders is not permissible within the 4 corners of the 96 Act. That's a clear, good guideline to follow. And second is divorce above, whether you should. Original and rejoinder.
Yes.
The broad guideline. Now come to section C, category C, lower down that first note itself, first note, opening note. What are those 12 or 15 principles? I'll read a sentence each. It's the same chart, but put in the point of submissions, put in the form of submissions. So first is true and genuine effectuation of the real intent of parties. But real intent where it becomes a form of avoidance, no, then the objective test comes in. Suppose you're also going to find in a case that the real intent actually by performance, by context, by negotiation is not to be involved. Then a lordship will say, no, there's no group doctrine. It's not bound by arbitration. Your lordship is entitled to the existing law. What is wrong with that law? My lord says enough tools not to punish an innocent party. Second, related part entities playing a predominant role both at the negotiation stage at the inception and in the performance. Now, suppose, both these tests, this is an answer also to the subjective objective which my Lord Chief Justice formulated. Suppose your Lordship gives a finding of fact in not this case, actual case, that I am fully involved in negotiation, plus I am fully involved in performance. But because I am a foreigner, I have so designed it that I don't want to be caught in arbitration. Doesn't matter. Sorry, it doesn't matter. Your Lordship should be able to control that. Absent such a group doctrine would allow evasion and avoidance of legitimate collective responsibility. That's a consequence. I'll leave that. Hypothetical approach. I'll leave that. Now, certainly the veil doctrine, even they have conceded. That's C.5. Even they are conceding in some form or the other. But certainly I am not agreeing that it is coincide with only the veil doctrine. Rest of what we have seen, a very, very important concept is C11. This is a judicial policy and a public policy. Not that any single swallow will make a summer. No single point is enough. But the totality a Lordship will see. In a genuine case where a Lordship gets a fragmentation, why should a Lordship allow it? In effect, you are using it to stop what? Legitimate arbitration. Look at your Lordship's pro-arbitration approach in a whole set of jurisprudence. In effect, C11 means you are thwarting arbitration because you are fragmenting it. In effect, no effective decree is passed. Then I've given C9, which is composite and all that. Anyway, this is just to remind my lord that all of these principles are there. I'm not reading all of them. There are about 12 or 14 of them. Well, there's a word here, then I go back to my agenda note. C15 and C16 are more important than they are given the weight of. Claiming through or under in the law commission is not being given enough weight by the other side. If that is so, Malus, then merely saying non-signatories will not, Malus, nullify this. I've given various reasons for C15 and C16. That has not been answered, that has not been really dealt with. That, according to me, Malus, I reiterate fully. The entirety of the law commission, the 2(1)H argument, section 8, I'm saving time, I'm not reading it, Malus. That is an important consideration in a particular case. Now I come, Malus, to my rejoinder note. And turn to my rejoinder note. Very quickly, Malus, I'll finish within time. First is, who is a party must be in accord and comply with principles of law of contract. That's the point. I'll not read the point, but I'll read the response. 72 of chloro in my CL1 provides for clear intent to bind signatory and non-signatory, cannot be restricted only to intention to consider peers for cooperative, voluntary, tight group structure. Same point I made. Second point made is party autonomy. So was the first point I really made. Fellowship appreciates what I'm saying. I'm not really reading it. First. Second is party autonomy. Kindly come to my response. It is essential to understand the true intent by way of their conduct. It is simply the reliance solely on party autonomy would negate the doctrine. This Honorable Court in ONGC in para 40 has laid down the test. Mutual intention, relationship of a non-signatory, commonality of subject matter, composite nature, performance of contract. What's the point of ring fencing with 5 safeguards? If it is so simple. Well, as party autonomy, then all this is useless. Clearly, I am a non-signatory. Clearly, I am not. What's the point of all the lordships? On the contrary, a lordship is finding a way to effectuate the doctrine while protecting. And that's the right approach. Third, privity of contract. Same answer. These are all traditional doctrines. Law will not advance if you go back to privity. Because how many categories does a lordship have where privity is not sacrosanct? Does a lordship have less categories of privity not being sacrosanct? Whereas there is a book by Michael Atiyah, which I read in my student days, The Beginning of the End of Contractual Intent. This is written almost 70 years ago. English people who are conservative found the beginning of the end of contractual intent. And a lot of us today told party autonomy and contractual intent is conclusive and dispositive. Maybe one of how the same cannot be the sole basis. In fact, case of non-signatory, this court has used the doctrine of piercing the cooperative. Non-signatory may be held to be bound on a consensual theory, found on agency, assignment, non-consensual basis, estoppel, altering. The courts have added additional elements, common intention, negotiation. These are juristic principles by eminent authors and a lot of judgments which has adopted those authors. Gary Bourne, etc. have given these theories. Then there was 4. It's a repetition, really. With the para given of para 39 ONGC. Para 4 is that. Now this through or under is para 5. Through or under. Through or under relates to my first note C15 and C16. Just to cross-reference it once. My first note C15 and C16. In addition, it has been held in para 73 of chloro that a non-signatory could be subject to arbitration without their prior consent in exceptional cases. The court may lay down the parameters which permit play in the joints. The court will examine these exceptions of the structure of direct relationship of the party to the agreement, direct commonality, and agreement between the parties being a composite transaction. Then this US and Germany, I'm not spending time in para 6. We'll come to para 8. A point I've already made for this. Compelling reason, entrenched doctrine in Indian law. Compelling reason not shown to your lordships. An entrenched doctrine is para 8. Para 9 was about implied consent, a phrase which fell from your lordship, section 7. The above submissions cannot be accepted for the reasons: A, doctrine be applied in facts, etc. Each case cannot be a straitjacket formula. And if your lordship were to find adopt this all or nothing, then there will be no grey area. Lordships can't handle individual cases in future then. Well, GCD is a reasonable and a natural extension of piercing the veil doctrine. Some or all already established legal tests regarding piercing would be applicable depending on individual facts. Then, you have chosen a private forum is argument number 10. Parties have a right to choose the forum and the parties to the agreement, but circumstances arise where a non-signatory company can be roped into arbitration because the court found the existence, quote unquote, from MTNL, a tight group structure with strong organizational and financial links so as to constitute a single economic unit or a single economic reality. If your lordship comes to that factual conclusion in a case, why should the tyranny of an intention doctrine defeat this? Is my question to myself. Then 11. Diwan and for Mr. Advani, but I would beseech my lords to keep one thing in mind. Your lordship already has sufficient guidelines. Naturally, your lordships can tweak it in this way, that way, little bit to make sure it's strengthened. But otherwise, there is nothing in this case in terms of either absolutist or completely. Otherwise, it would actually wreak havoc on what is now an established trend of law. That's a very deep.
Dr. Singhvi, amongst the multifold talents that you have, you also have the talent of lip reading. Lip reading.
Even if I did, I would not disclose. It's a very valuable talent so long as it's kept hidden.
That's a talent by itself.
I can assure lordships, I don't. I don't. And I'm glad to hear the subtext of what a lordship says seems to be in my favor, but I don't know. I'm never presumptuous about adjudication.
Dr. Singhvi, you may not want to
Because you closed.
You may not want to reveal a bar secret, but I can tell you a secret which I picked up. I was sitting exactly where your junior is sitting, and where you are standing, Mr. Fali Nariman was leading me. That was the withdrawal of the prosecution of the Chief Minister's power under Section 321 of the CRPC.
Oh, yes.
Had come up and had been referred to a constitution bench presided by Chief Justice Bhagwati. Original
Shivnandan
judgment-
Paswan was.
Right, Shivnandan.
I was on the opposite side.
83 Supreme
I
Court.
was on the opposite side.
And, that was where just Bharoli.
3-2. Justice Venkatramaya, 3-2.
That's right. They ultimately, the matter went 3-2 in the
That's
constitution.
right,
bench.
3-2.
So the judges were conversing, and I was briefing sitting by the senior Mr. Nariman. And I thought that I'll use the time, to tell him what our next line of authority was going to be. So he turns to me and says, never speak when the judges are speaking. So I said, sorry, Mr. Rai. When we left the court at 4 o'clock, he says, that's when you get to know the mind of the judges. Something which has not left me, learning lessons on the grades at the bar.
I shall pay more attention to this very wise advice.
We are now inventing how to read the minds of lawyers while sitting here.
I believe that.
Deeply obliged.
Very
Very deeply obliged.
Your lordships know what happens when we are on this side.
Yes.
Plus, I'll just take about a minute and a half, 10, 15 seconds for me
I never forgot.
respond to what Ms. Arora said.
Yeah.
1 minute, to respond. As far as the submission which Ms. Arora had made, there's just one aspect I want to point out. That while it is a section 9, the entire determination which your lordships will see at paragraph 6, 7 and 12 of the judgment was only on the group of companies doctrine. So as far as the issue is concerned, the issue is in fact the identical issue that your lordships is hearing in 501. So it shouldn't be delinked in any form. That's the only one point I want to make. There's just one thing that fell from my Lord Justice Narasimha, which is in relation to has the critical mass of cases been brought before my lords to say there's some kind of abuse or not. Because I think there are two ways to look at this point. The first way, my lords, is which are the two countries we are akin with, at least as far as adoption of the model law is concerned, and my lords, the localized theory, England and Singapore. And both those countries have rejected the doctrine, we have not. So are you really consistent with two other countries which follow us the same meters? My respectful submission is no, that's one part of the critical mass. Look, I don't want to give you evidence at the bar, but I can tell your lordships that there are at least 15 or 20 cases where I have been involved with. International, domestic, where these issues crop up very, very often. Now, obviously, they're not there before my lords because if a section 16 gets dismissed and jurisdiction is upheld, because awards take time to come, 34s are challenged, the issues may not be there before. But there are a number of these issues, and therefore, when your lordships is considering it, all I am requesting for is bringing about a level of certainty. Now, why would I not apply this if I was in Singapore and London? I wouldn't apply it there because if a group structure is brought, party takes a simpler route. It goes to the English Commercial Court, or it goes to the Singapore International Commercial Court, or it goes to the Singapore High Court, and says, I don't need to go to arbitration. I have a great commercial remedy. I go to court, I get the injunction I get a trial disposed of within 2 years, 3 years, and that's the end of the matter. We have a commercial court structure here. And that's really,
let's give 5 minutes to Mr. Advani.
I'm just grateful, my lords, for a very patient hearing. And I must just point out to my lords one very interesting aspect. It's a very personal aspect. The first time I appeared before a CB was in 2012 in the Balco case, when I appeared for the Singapore International Arbitration Center, which had filed an intervention application. And I got my 7.5 minutes on that side of the table, right towards the end. Because this is, in fact, from an arbitration perspective, the second time, I've appeared before other CVs, over that 10, 12-year period. But from an arbitration perspective, this is the second time I've actually addressed a CB on
Thank you, Mr. Thank you.
And I'm deeply grateful for a very
Thank you, Dr. Singhvi. Yes, Mr. Advani.
I just want to present a slightly different perspective. I'm not going through any case law. Your lordship has heard it all. But all institutions all over the world, and I have been part of two of them, the Singapore Arbitration Center and the Dubai Arbitration Center, the appointment of arbitrators is done by the institution. It is not a big judicial exercise. They are prima facie appointed, and then the arbitrators go into the issues, whether the group company doctrine or any other theories that are there when non-signatories can be joined, and based on the facts, they make the decision. And now here also under our section 11 has been amended. It has not come into effect, but I'm told it's very close to coming into effect. The draft rules of the institutions have been published and that process is on. Ultimately, it will be the institutions doing this role that your lordships are doing today. So if your lordships leave the issues open as widely as possible for every conceivable issue where the arbitrator thinks it's appropriate to join a non-signatory, let him take the decision. There may be 7 different theories. Why should your lordship confine them? After all, if your lordship recollects, the whole group concept concept of group companies has come from where? From Dow Chemicals. It's come from an award. It's not come from a court decision. And since now we're also going toward the appointment of arbitrators by the institutions appoint only prima facie. Arbitrators will come to finding the fact one way or the other and decide this issue. And we've also done arbitrations all over the globe. The arbitrators have considered it sensibly and joined or refused to join party. This is happening consistently all over the globe. Why are we taking a restrictive view to this? Let's keep all the judgments are in place. They're well reasoned. Why do they need to be tinkered with? We have a stable body of judgments. Let the arbitrators follow them, whichever route they think is appropriate. They'll either agree, they'll join the party, or they won't join. Why do we do a narrowing exercise? Let the exercise be as broad as possible. And if an arbitrator goes too much out of line, the courts are there to correct him in a 34 application. So lordships will keep the judgments exactly as they are. The points raised in Justice Ramana's judgment were already answered by Justice Suryakant's judgment. There are several different tests. Why does your lordship want to narrow them? Let the arbitrator apply it depending on the facts of each case. And sooner or later, this is going to be an institutional exercise, not a court exercise. But let's leave it as wide as possible. Let's leave the arbitrators ample room to take decisions. And if they go so wrong, the courts will correct them. Now, that was just a perspective I wanted to give your lordships. I'm obliged.
Thank you, Mr. Bani. Thank you very much. So, we'll
I just had a small request to make.
conclude judgment reserved. Yes.
I just had a small request to make, Milad. We had also intervened IAA 58750 of 2023. May I have your lordship's leave? We'll put in written submissions. I want to prune it down in view of what has transpired.
Not more than 2 pages.
Absolutely, Milad. We'll try and keep it short. Grateful, Milad.
Thank you. Thank you. Thank you.